Welcome to Chapter 6, the Court System and ADR, Alternative Dispute Resolution. This lecture will probably be broken down into at least 2 different videos, maybe more, because there are a lot of slides in this presentation. The other thing I wanted to say is that, the topics that I covered in the Chapter 5 videos and what I'm covering today, they really are, it could be a course unto themselves. I'm just hitting the basics. I am hoping that you remember things from your high school civics class, and just keep that in mind. Everything that we do in the intro class is just an overview, and that you'll get to more in depth in later legal specialty classes. So, as paralegals, you need to understand the different types of court systems, the different types of courts, and the litigation process as a whole. So here in the beginning of this chapter, we're going to be talking about the court systems, the structure, and both the federal and the state. And then the second part of the chapter is about alternative dispute resolution, what alternatives we have to the litigation process, and what you, the paralegal, can do to facilitate those processes. So the next 2 slides, and I have the links there, they are crash course videos about government, about the structures of the court systems. So make sure that you go and watch those. I can't watch them within the presentation, but they have some really good information, and they will help refresh your memory with regard to the structure of our courts and our legal system in general. So we're going to be focusing today in this chapter on the judicial branch. Remember that we talked in Chapter 5 about the 3 branches of government that were created by the Constitution, and then we also discussed that quasi-4th branch, the administrative agencies. But today we're going to talk about the judicial branch. In the United States, we are divided into 2 separate court systems. We have the federal system and the state systems. So that means that we have 52 court systems in the United States, one for each state and one for the District of Columbia, and then the federal system. Now, does that mean that the federal courts are superior to the state courts? No, they are operating independently, having different authority that they have derived from different sources. There are only certain situations where the courts might overlap the state and the federal system, and we'll talk about that as we move forward. So this video is about federalism, and we talked a little bit about it in the Chapter 5 lecture. Federalism is about the state and federal governments sharing power. They are operating at the same time independently, and the only concern is that if something in the state system conflicts with the federal, then the federal will win out. So, how do you get into court? Well, the first thing is you have to have standing. Standing is what I like to call, you gotta have a dog in the fight. You have to have a sufficient stake in the issue. You have to have a legally protected, genuine interest and have suffered some harm. Just because you don't like a law, that does not give you reason to sue. You have to have suffered some harm. Sometimes you can sue on behalf of another person or an estate, but for the most part, that harm has to be to you. And the controversy has to be something that is justiciable, meaning something that the courts can actually make a decision about. Not an esoteric theory. It has to be something that we call justiciable. Real and substantial, not a hypothetical, not an academic approach. It has to be something that actually has harmed you. So the last of these three videos talks about general and specific jurisdiction. What that means is that if an individual lives within a particular state and they have, if they are a resident of that state, a court in that state has general jurisdiction, general personal jurisdiction over them. However, if they have availed themselves of something within another state or had some of those minimum contacts, that court in the new state where they are not a resident can have specific personal jurisdiction over them through the long arm statute and through those minimum contacts. The next type of jurisdiction we're going to talk about is jurisdiction over property. It's also called in rem jurisdiction. It means that that particular court has the authority to litigate matters that involve property within its boundaries. Okay, so court has jurisdiction over property when the property is the subject matter of the dispute, whether it's real or personal property. It's located within that court's boundaries, within that state's boundaries, and so it has in rem jurisdiction over that property. The next is subject matter jurisdiction. The court has the authority to litigate, adjudicate a legal matter of this type. So now we're focusing on what is the type of case this is. And courts have either, and see, this is where we're getting into more confusing, they either have, it's a court of limited jurisdiction or a court of general jurisdiction. Okay, well, what does that mean? We now are using general in a different way. It means that there are courts that can hear lots of different cases. If you are in the Superior Court of Clark County, they can hear divorce cases, they can hear criminal cases, they can hear tort claims, they can hear breach of contract cases. So they have very varied types of cases that they can hear. But then there are smaller courts that have very limited jurisdiction. The juvenile court only can hear certain types of cases. Probate court can only deal with certain types of cases. The magistrate can only deal with certain types of cases. So they have a limited scope, a limited jurisdiction. So how do you determine what that subject matter jurisdiction is? It depends on the subject matter. If it's a criminal case, is it a misdemeanor or a felony? That could determine which court has subject matter jurisdiction, how much money's involved. If I am suing my neighbor, if it's less than a certain amount, it's probably going to go to small claims court. If it is a greater amount, then I possibly can go directly into Superior Court. Is it a trial or is it an appellate issue? For example, let's say that we had an issue that was in probate court. And we go before the probate judge, we are not happy with the outcome. That probate court is acting as the trial court. So if we want to appeal that probate judge's decision, we're going to appeal to the Superior Court for that county, and now the Superior Court is acting as an appellate court instead of a trial court. So keep that in mind. Sometimes when you're reading cases, you have situations where what normally would be the trial court, they are actually acting as an appellate court. So here we have a video on subject matter jurisdiction, okay, about what types of cases a court can hear. Okay. Then you have a concept called original versus appellate jurisdiction. So you see now we're getting where types of jurisdiction, concepts of jurisdiction are overlapping. Original versus appellate. Original jurisdiction is a power of a court to hear the case for the first time. So in my example that I just had, we were appearing before the probate court in a particular issue. Let's say that we wanted to, we were not happy with granddaddy's will, and we want to contest that will, and we went to probate court to contest the will, and the probate judge ruled in favor of the estate, and now we want to appeal that decision out to Superior Court. That probate court had original jurisdiction. They had the trial, in quotes. We weren't happy with that decision, so now we're going to move out to the Superior Court for that county, and that Superior Court is acting as an appellate court, so they have appellate jurisdiction. They have the power to review the decision of a lower court beneath them. We also have exclusive versus concurrent. Exclusive means that only this court can hear this case. They're the only court that will hear it. Concurrent means that we have more than one court that can hear our case. Okay, and we're going to talk about diversity of citizenship jurisdiction that leads to concurrent jurisdiction between courts. We'll talk about that in just a little bit. But when there's more than one court that could hear your case, that then means that we as attorneys and legal professionals are going to evaluate which of those two courts, or maybe even three, those two courts is the better place to have our case heard. And that's known as forum shopping. And there's lots of reasons for why you would choose one court over another. Maybe I'm more familiar with Court A versus Court B as an attorney. Maybe I know that in Court A, I can get to trial faster than if I choose Court B. Maybe my trial strategy is that I don't want to get to trial fast, so I want to choose Court B. So it's a analytical process for deciding which of those courts is a better fit for this case, for these parties, and I make a decision on which court that has concurrent jurisdiction I want to file my case in. Here's the slide on forum shopping. Questions to consider. Which one is likely to be more sympathetic to my client? Where can I get to trial quickly, or where can I go to have more of a delay? How do the judges in each of those courts apply the law? As I said, am I more familiar with Court A versus Court B? Is there some type of advantage that one court has over the other? Now, we're going to look at specifically jurisdiction in federal court. How do you get to federal court? Well, there's two ways we can get into federal court. One is that we have an issue that's a federal question. It has something to do with the Constitution or a federal statute or a federal administrative regulation. It deals with federal law. That's the first way I can get into a federal court. The second, and the one that leads to a little bit more analysis, is diversity of citizenship, so diversity jurisdiction. If my issue involves people from two different states, okay? So let's say that my client, the plaintiff, is from Georgia and the defendant is from South Carolina. And let's say that the cause of action happened in Tennessee, okay? I can make a decision about where I am, if I want to get into federal court, because because the parties are from two different states. Then let's say it was a car accident, and my plaintiff drives a nice big SUV that's valued at $80,000. As long as I have the issue in controversy deals with more than $75,000 in damages, and I have parties from two different states, I can file my case in federal court. So we have either a federal question, or we have diversity of citizenship and damages in excess of $75,000. Okay, so if it's a federal question, then the federal courts have exclusive jurisdiction. But if it is a diversity of citizenship issue, then the federal and the state courts are sharing or having concurrent jurisdiction. And the plaintiff, can decide whether to file the case in federal or in state court. Now, we still would have to deal with issues of subject matter jurisdiction and personal jurisdiction, but right now we're just looking at, do we want to go in federal court or do we want to be in state court? So you can see there that there, our little Venn diagram where we have exclusive federal jurisdiction. So if it's something that deals with federal law, such as bankruptcy law, it's exclusively going to be in a federal court. If it's something that exclusively deals with state law, it's going to be in state court. But if it crosses over, then there's concurrent jurisdiction between the federal and the state courts. So then we also are getting into some other types of jurisdiction. We talked a little bit in Chapter 5 about cyberspace and law in cyberspace. We've got an issue when you're dealing with a transaction that happened online. We've got, you know, if the other party operates only online, then we've got to make a decision about what courts are going to have jurisdiction. And there's a sliding scale. Does that defendant do substantial business over the internet? Do they do something from a physical location somewhere? Do they passively advertise in that particular jurisdiction where we are? So there's several different factors that go into deciding jurisdiction in cyberspace, and it's one of those things that's kind of ongoing because we are seeing more and more cases that originate from transactions within cyberspace, within the internet, and so it's constantly evolving. Then you also have another issue of international jurisdictional issues. What if you know, that particular defendant is you know, only location is in China and they're doing everything else, you know, on the internet. So you're pulling in so many different issues when you're dealing with cyberspace jurisdiction. Now, venue. Venue and jurisdiction are different. Venue means what court is the most appropriate location for a trial. Usually it's going to be in a geographic area, you know, the geographic area where the problem occurred, the issue, the cause of action. Usually it's going to be at a county level. But sometimes there is so much publicity associated with a certain case that it requires what we call a change of venue. And what that means is there's been so much publicity around this particular issue, this particular plaintiff or defendant. Usually it happens in criminal cases, so it centers around the publicity around the defendant or the crime, and it becomes, you are unable to find a fair and impartial jury, and so you file a motion for a change of venue. One in the relative recent past here in Georgia was the Ross Harris case in Cobb County. That was the hot car death of Mr. Harris's son, and he was charged in that issue, in that case, and the Okay, so I had to pause the recording. I had an interruption, so I'm not real sure where I left off. Talking about the Ross Harris case. So that is the hot car death. It was in Cobb County, and there was a tremendous amount of publicity. So the defendant, Mr. Harris's attorney, filed a motion for a change of venue, somewhere where he thought that there could be a more impartial jury, and the judge granted that motion. Although I think in the state of Georgia, you'd be real hard pressed to find anybody who didn't know about or have heard something about the case. But when you have a change of venue, you have to move it to a location that has a similar population size, excuse me, similar demographics. And what happens is you just pick the trial up and move it to that new venue. And the only thing that's different is that the jurors are now going to come from that location. So in the Harris case, it was moved from Cobb County to Glenn County, which is down in South Georgia, right on the coast. And they moved it to that county seat, to Brunswick. And so they then got a jury pool from Glenn County, and they chose their jury from them. It was determined that Brunswick or Glenn County was similar to Cobb County in size, demographics, population, and so that's where they moved the case. So depending on how much publicity is involved in a particular case, it could possibly be moved. But as we become more and more of a global society, it's going to be difficult to find locations that don't have or haven't heard about a particular case. So every court has its own set of procedural rules. But within, let's say, the federal court system, there are rules that are specific to, civil procedure within the federal courts, criminal procedure within the federal courts, and then the same applies to the state. They will have the state of Georgia rules of civil procedure and rules of criminal procedure. It's going to be different for criminal and civil. But then you also have specific courts. Let's say the superior courts of Clark County may have a set of rules in addition, and a particular judge, a specific judge, may have their own rules with regard to their court. So that's one of your tasks as the paralegal, is to make sure that you find out what the rules are for that jurisdiction, for that court, and make your attorney aware of anything that's outside the norm. So the federal court system is a three-tiered system. You have the United States District Courts, the United States Courts of Appeals, and the United States Supreme Court. So that is the system. The trial courts are the district courts, the U.S. District Courts. The intermediate appellate courts are the United States Court of Appeals, and then the court of last resort is the United States Supreme Court. And we'll talk about those different courts in just a minute. But all federal court judges are appointed by the president, confirmed by the Senate, and they are lifetime appointments. So they're there forever. Okay. So here is a flow chart of the courts. You have the Supreme Court at the top. You have the intermediate level, the courts of appeals, and we're going to talk about those different courts in just a moment. You've got 12 Court of Appeals, and then you also have one that's the 13th, but it's not called the 13th. It's the Court of Appeals for the Federal Circuit, and they deal with specific subject matter, no matter what of the district courts it comes from. And then you have tax court, bankruptcy court, district courts underneath. Those are the trial courts, and the trial courts for the Federal Circuit, Court of Federal Claims, and Court of International Trade. So first let's talk about the district courts. They are the trial courts. It's equivalent of a state trial court, but in the federal system. There is at least one federal district in every state. Here in Georgia, we have three. We have three district courts. We have the Northern District, the Middle District, and the Southern District. And there are 94 districts across the country. And but every state has at least one, and they have original jurisdiction, which we just talked about, in any matters dealing with federal law. Okay, they hear either federal question cases or diversity of citizenship cases. Here we have a video about what is federal question jurisdiction and a video on diversity jurisdiction. This U.S. Essentials YouTube channel has a lot of great videos, a lot of good information. Okay, then you have the intermediate appellate courts. And those are the United States Court of Appeals. There are 13 courts of appeals. You also will hear them called the U.S. Circuit Courts. They will hear appeals from the trial court, the district court, and in most circumstances, they will be the final decision, okay? Unless it is something that the Supreme Court accepts a writ to hear. Excuse me. Judges are appointed for life. Usually when it goes to the Court of Appeals, it's a panel of judges, usually 3 judges, that will hear the case. Rarely does it go before the entire in-bank judges on the Court of Appeals. So this is a diagram, a map of the United States showing the 13 districts. As you see, we are in the 11th district with Alabama and Florida. What will be interesting, confusing, is that when you get into legal research and writing, and you start talking about the regional reporters, our regional reporter is actually, we're grouped with South Carolina, North Carolina, Virginia, and West Virginia. But that is not the case here with the circuit courts. We were originally part of the 5th Circuit. And then in 1980, it was decided to split the 5th Circuit into the 5th and the 11th Circuit because it got so big. So you have, excuse me, in this diagram, you have each of the circuit courts, and the dotted lines within the states are the district courts. So here you have the northern, the middle, and the southern in Georgia. You look in many states, there's only one district court: Montana, Idaho, Wyoming, Utah, Colorado. They only have one district court. You see the bigger states, the bigger population states, have more than one district court. You then have a circuit for the DC area. It's not called the 12th circuit, it's called the DC circuit. And then you have that federal circuit, not called the 13th, that federal circuit that hears specific subject matter cases. Then you have the U.S. Supreme Court, highest level of the federal court system. It's the court of last resort. There are 9 judges that sit on the Supreme Court, appointed for life. They mostly work as an appeals court. However, they do have original jurisdiction in some cases, very specific cases. There is no absolute right of appeal to the U.S. Supreme Court. The parties have to file a petition for certiorari, which we just say cert. And if 4 of the 9 justices agree to hear the case, and we call that the rule of 4, 4 of the 9 agree to hear the case, then the court will issue a writ of certiorari or a writ of cert to hear the case. Usually they're only going to hear cases that really raise some important constitutional questions. So, you know, they are not going to hear everything. Usually it's got to be something that either has not been decided yet or really involves some very important constitutional issue that they feel needs to be heard. So I'm going to stop that video because we're already at 36 minutes, and I will pick up with the state courts in the next video.